So in this case, BGC Partners and Hickey, the former employee, Mr. Anthony Hickey, worked for BGC Partners for a number of years. He worked as a broker in interest rate swaps. He was earning an annual salary of $400,000 plus additional bonuses and entitlements, and he was under an employment contract for a fixed period of time, which had been extended on a number of occasions, but the most recent one was due to end on the 31st of July 2018. The contract could only be terminated in the last 2 weeks of the fixed term contract by either party, and then they were required to give a period of 3 months notice when the employment would end. The contract also had a number of post-employment restraints that Mr. Hickey could not solicit clients away from the business, and also provided the employer with an option that they could exercise so that they would pay him for 6 months, and in that time he couldn't work for a competitive business. In late last year, Mr. Hickey purported to give his resignation on 1 month's notice. Despite what his contract said, his reasoning for the 1 month's notice was that under the Banking, Finance and Insurance Award, employees with his length of service only had to give 1 month's notice. Mr. Hickey finished up employment the following month, and BGC objected to his purported resignation on the basis that the contract didn't allow him to resign, and that he was to be employed up until the 31st of July. BCG came back and said that if they were wrong about that they were exercising their option to restrain him from working for a competitor. What was interesting was that shortly after giving his resignation, he signed an employment contract with a competitor, ICAP, Australia Proprietary Limited. The terms of the contract were that he would receive a $500,000 signing-on bonus, a salary of $300,000, and ICAP would indemnify him for any legal costs as a result of his resignation. BGC obviously brought proceedings in the Supreme Court, trying to declare that the contract had not been repudiated, and that it remained on foot, and also an order restraining Mr. Hickey from working for ICAP during the post-employment restraints. The court found that despite Mr. Hickey's clear and blatant breach of his employment contract, he was to be restrained for a period of 9 months, which was calculated as the 3 month notice that he would have had to give at the end of his contract, and that 6 month notice, the 6 month restraint period that they were required to pay him for. So in effect, he was restrained from working up until September this year, in which case BGC had to pay him during that entire time, and ICAP paid his legal costs, and he was free to start work with him soon after the restraint ended.
I think there's a number of interesting issues at play in this case, particularly because it centres on the brokering industry. The judge made quite a few comments about the fact that industry has relatively few players and there's a lot of demand and competition for senior brokers, and I think that really played a lot into some of the public policy and other decisions around would a restraint be reasonable and how long would it be reasonable for. So the judge in this case found that a 6 month post-termination restraint would be reasonable because BGC would need that amount of time to establish and firm up the relationships with its clients. There was some discussion about the various events that they hold with clients, that they go on trips, and there's very sort of personal long-term relationships built. So I think in this case, given the industry, given the key role of brokers and the face-to-face sort of contact they have with clients, that 6 months was found to be really reasonable.
I think that in some ways Mr. Hickey can be fortunate that he wasn't restrained longer. I mean, there's cases with that type of relationships and that type of remuneration where there's been even longer periods of restraint. particularly in relation to client relationships. We've seen in the past, including obviously in the recruitment industry, but also professional services. So he could well have ended up with a longer period of restraint.
I think another aspect which is important for employers to think about in terms of hiring senior employees is having a longer term notice period can provide protection for them in terms of being able to remove that person from the duties and have them away from client contact but still being paid without the uncertainty of having to potentially litigate over what would be a reasonable restraint. So that's something that certainly employers in this position thinking about what they could do could quite easily implement, a 3, 4, 5, 6 month termination period if that's something that's going to provide additional protection.
Yeah, it just depends, and it's a matter of balancing how much financial loss or potential financial loss arises from the person going to competitor versus the cost of paying them, or the cost, if they're not a good performer, of having to pay them in lieu of notice if you decide to terminate for poor performance.